Thank you for visiting the Combs Waterkotte YouTube channel. We are a leading criminal defense law firm in Illinois and Missouri, with over 600 perfect reviews and a long history of client satisfaction, criminal case dismissals, charge reductions, and victories. Our firm has created these audio articles to help protect your freedom, reputation, and rights. If we are hired for your case, we will not give up until you receive fair justice. Unlawful Restraint Lawyer, Chicago, Illinois. Being charged with unlawful restraint in Chicago, Illinois can put your freedom, reputation, and future at risk. Illinois prosecutors take kidnapping-related allegations seriously, and a conviction could lead to jail time, high fines, and a felony on your permanent criminal record. If you've been arrested or accused of unlawful restraint in the Chicago or Cook County area, it's important to speak with an experienced criminal defense attorney as soon as possible. At Combs Waterkotte, our criminal defense lawyers have decades of combined experience defending clients against serious criminal charges throughout Illinois. We understand that every unlawful restraint case has its own circumstances, and we work to build a defense strategy tailored to your situation. Whether you're facing false accusations, misunderstandings, or complex legal issues, our team is here to fight for the best possible outcome in your case. Unlawful Restraint Lawyer in Chicago, Illinois, serving all of Cook County. An unlawful restraint charge in Chicago, Illinois can quickly become overwhelming. Prosecutors in Cook County aggressively pursue these cases, and even a single accusation can place your freedom, reputation, and future opportunities at risk. Whether the allegations stem from a misunderstanding, exaggerated claims, or false accusations, you need a criminal defense lawyer who will take your case seriously from day one. At Combs Waterkotte, we understand how stressful it is to face unlawful restraint charges in Cook County. Our experienced criminal defense attorneys have decades of combined experience defending clients against serious felony and misdemeanor allegations throughout the Chicago area. When you hire our firm, we'll carefully examine every aspect of the prosecution's case, including witness statements, police reports, and any potential constitutional violations that could weaken the charges against you. From the very beginning, our goal is to pursue the best possible outcome for your case, whether that means negotiating for reduced charges, seeking a dismissal, or fighting for you at trial. We build personalized defense strategies tailored to the unique facts of your situation and remain ready to protect your rights every step of the way. If you're facing unlawful restraint charges in Chicago or anywhere in Cook County, contact Combs Waterkotte online or call 312-500-HELP today. The sooner you secure legal representation, the stronger your defense can be. What is unlawful restraint in Chicago, Illinois? Under Illinois law, the unlawful restraint statute is very short and straightforward. It says that an individual commits unlawful restraint when they knowingly and without legal authority detain another individual. That's all there is to it. It's a simple 18-word law. Another related kidnapping offense, on the other hand, forcible detention, is a bit more complex and nuanced. This statute covers offenses in which someone hold an individual hostage for the purpose of obtaining a ransom from a third person while the hostage taker is armed with a dangerous weapon, or the hostage taker knows their hostage is a law enforcement officer. Obviously, forcible detention is a much more serious offense. Cases of forcible detention are rarer, but the potential consequences for a conviction are much more punitive. Unlawful restraint, on the other hand, is intentionally broad. It may apply in several scenarios, including domestic violence situations, assault or battery cases, or cases that involve gang-related activity. Either offense comes with the possibility of serious prison time, Is unlawful restraint a felony in Chicago, Illinois? Yes, unlawful restraint is a felony offense in Chicago and Cook County. Specifically, the offense is charged as a Class 4 felony. A Class 4 felony conviction can result in 1 to 3 years in prison, 3 to 6 years in prison for an extended term sentence, a potential fine up to $25,000, forcible detention with its hostage, deadly weapon, and law enforcement-related components is a Class 2 felony offense. A Class 2 felony conviction in Chicago or Cook County can result in 3 to 7 years in prison, 7 to 14 years in prison for an extended term sentence, a potential fine up to $25,000. Because of the violent nature of unlawful restraint and forcible detention, a felony conviction for either offense can come with a slew of collateral consequences. Some of the most common of these collateral consequences include employment barriers. An unlawful restraint felony conviction in Chicago can limit job opportunities by appearing on background checks, disqualifying applicants from sensitive positions, and causing employers to question judgment, trustworthiness, or workplace safety concerns. Housing issues. A felony unlawful restraint conviction may make securing housing difficult because landlords often deny applicants with violent or felony records, especially in competitive Chicago rental markets and subsidized housing programs. Professional licensing impacts. Illinois licensing boards may deny, suspend, or revoke professional licenses after an unlawful restraint conviction, particularly for careers involving health care, education, child care, security, finance, or public trust responsibilities. Orders of protection. Unlawful restraint charges frequently involve domestic allegations, and courts may issue orders of protection restricting contact, communication, shared residences, parenting time, or access to certain locations or individuals in Chicago and Cook County. Firearm rights. A felony unlawful restraint conviction generally results in the loss of firearm rights under Illinois and federal law, prohibiting firearm possession, purchases, concealed carry licensing, and ammunition ownership. Unlawful restraint versus kidnapping in Chicago, Illinois. What makes unlawful restraint charges different from kidnapping charges in Chicago and Cook County, Illinois? Illinois' unlawful restraint statute specifically does not define the word detain, which means unlawful restraint is a very broad offense. To commit unlawful restraint, an alleged offender does not need to tie someone up, lock them in a room, move them to another location, or even physically touch the alleged victim. Unlawful restraint can be charged in Illinois for actions as simple as blocking exists, cornering someone, grabbing someone's arms or clothing, taking someone's car keys, threatening to use force if someone tries to leave. As such, unlawful restraining is typically used as a fallback charge when Cook County prosecutors aren't confident that they can achieve a kidnapping conviction. It's also commonly used as a companion charge alongside criminal sexual assault or criminal sexual abuse. Illinois' kidnapping law, on the other hand, is applied much more narrowly. The kidnapping statute says someone commits the offense when they knowingly, secretly confine someone against their will, take someone elsewhere using force or the threat of force with the intent to confine them against their will, deceitfully entice someone to go somewhere with the intent to confine that person secretly against their will. Kidnapping requires much more intent and agency than unlawful restraint. This is reflected in the felony charges associated with each offense. Kidnapping is a Class 2 felony, while unlawful restraint is a lesser, but still severe, Class 4 felony. Criminal defense strategies against Chicago. Unlawful restraint charges. If you've been charged with unlawful restraint in Chicago or Cook County, you need the help of a criminal defense attorney right away. At Combs Waterkotte, we've taken on kidnapping-related charges for Chicago defense clients before, and we've found the following criminal defense strategies effective in securing reductions, dismissals, and even trial acquittals. Challenging whether the alleged victim was actually restrained. A common defense in unlawful restraint cases in Chicago consists of arguing that the alleged victim was never actually prevented from leaving the encounter. Prosecutors must prove the defendant knowingly detained another person without proper legal authority. Defense attorneys may present evidence showing the individual could move freely, voluntarily remained at the scene, or was never physically blocked or threatened. Surveillance footage, witness testimony, text messages, and inconsistencies in police reports can all help undermine allegations that unlawful restraint actually occurred under Illinois law. Consent as a defense to unlawful restraint charges. In some Chicago unlawful restraint cases, the defense may argue that the alleged victim voluntarily agreed to the interaction or situation. Consent can become important when accusations arise from personal disputes, domestic arguments, or misunderstandings between acquaintances or romantic partners. Defense lawyers may use witness statements, surveillance video, phone records, or prior communications to demonstrate that the alleged victim willingly stayed or participated. If prosecutors cannot prove the detention occurred against the person's will, the charges may be reduced or dismissed. Lack of intent to commit unlawful restraint. Cook County prosecutors must prove a defendant knowingly restrained another person without legal authority. A defense strategy may involve showing there was no intent to detain anyone unlawfully. For example, an individual may have accidentally blocked a doorway during an argument or misunderstood the situation entirely. Defense attorneys typically argue that the conduct was incidental, brief, or unintentional, rather than criminal. Demonstrating confusion, miscommunication, or accidental conduct can weaken the prosecution's ability to establish the required mental state for conviction. Self-defense or defense of others. Some unlawful restraint allegations arise during fights, volatile domestic disputes, or emergency situations where a person acted to prevent harm. In these cases, the defense may argue that the defendant briefly restrained someone to protect themselves or another individual from immediate danger. Illinois law generally allows reasonable force in self-defense or defense of others under certain circumstances. Defense attorneys may present evidence showing the defendant's actions were necessary, proportionate, and motivated by safety concerns rather than criminal intent or unlawful detention. Challenging witness credibility or conflicting statements. Many unlawful restraint prosecutions in Chicago depend heavily on witness testimony rather than physical evidence. Because of this, defense lawyers often scrutinize inconsistencies in statements given to police, prosecutors, or medical personnel. Contradictory accounts regarding how long the alleged restraint lasted, whether threats occurred, or whether the person attempted to leave at all, can weaken the prosecution's case. Attorneys may also explore motives to exaggerate or fabricate allegations, especially in emotionally charged domestic disputes, custody battles, or relationship conflicts common in Chicago criminal cases. Arguing the alleged restraint was too brief or incidental. Not every physical confrontation or argument qualifies as unlawful restraint under Illinois law. Defense attorneys may argue the alleged conduct was too brief, minor, or incidental to constitute criminal charges. For example, standing in someone's way for a short period during a heated argument may not necessarily satisfy the legal definition of knowingly restraining another person. Defense lawyers often emphasize the short duration of the encounter, lack of force, and absence of threats or confinement to argue that prosecutors cannot prove unlawful restraint beyond a reasonable doubt. Fourth Amendment violations and illegal searches. Defense attorneys may challenge evidence obtained through unlawful searches, seizures, or arrests that violated the defendant's Fourth Amendment rights. If Chicago police conducted an illegal search of a home, vehicle, or cell phone without proper legal authority, any evidence from those searches may become inadmissible in court. Suppressing unlawfully obtained evidence can significantly weaken the prosecution's case and sometimes lead to dismissed charges. Constitutional challenges are especially important when police reports rely heavily on improperly gathered physical evidence, recordings, or statements obtained during questionable investigations. Miranda rights and improper police interrogations. Statements made during police questioning can become central evidence in unlawful restraint cases in Chicago. If law enforcement officers failed to advise the defendant of their Miranda rights properly before an interrogation, defense attorneys may seek to exclude those statements. Lawyers also examine whether officers used coercive tactics, intimidation, or prolonged questioning to obtain incriminating admissions. Successfully suppressing statements can severely damage the prosecution's case, particularly when the allegations rely largely on conflicting witness accounts rather than physical evidence. Combs Waterkotte is a leading criminal defense law firm serving the entire states of Illinois and Missouri. We have offices in St. Louis, Chicago, Kansas City, Clayton, Branson, and Belleville. We look forward to helping you with your criminal defense attorney needs.